Hey, you found a phenomenal deal. You signed the contract and you even put down earnest money, and then the worst happens. The seller ghosts you. See, they just change your mind, and unfortunately, it happens more often than you think. And if you're trying to force a closing, you need to know exactly where you stand legally when it comes to finding yourself in this type of position. In fact, what spurred this video is that I saw a question pop up on Reddit this past week from an investor who was stuck in this exact same nightmare where a short sale, where the seller decided, hey, I don't want to sell my property any longer, and he actually walked away from the deal. Now, see, this Reddit question perfectly illustrates the single biggest contractual risk for any of you real estate investors who are looking to engage in short sale transactions. And what I've found, it's typically seller's remorse. So when you're dealing with a motivated seller that, typically they're in a tough spot and they're trying to short sell their property, what I've experienced in my own dealings here is that these types of sellers, it's like fishing. They're volatile, and you got to be really careful in reeling these guys in, because if something comes along that changes their position, they may bounce on you and decide, hey, I'm going to back out of this, because they're under duress. And so the moment they get a better offer or this possible pathway to hope, they end up bailing. And I have lost deals when I used to engage in short sale transactions in the Las Vegas market about 10 years ago. This was a common occurrence that I was running into with sellers who were at the table ready to close, and then when it came down to signing on the dotted line, they were looking for ways to get out. Well, what I'm going to cover today is you only have two paths basically to get out of this when a seller tries to back out. And more importantly, we're going to talk about some of the contract language you should have in your agreements that you need to make sure that's in there today, so you never have to face this situation again in the future. So now we understand this is generic in nature, and I'm not going to talk about anything state specific because it really doesn't matter on a state specific standpoint. What this responds to is how you deal with these sellers, how to set up your contracts, and let's make sure you're protecting yourself. Okay, so let's start with the real money here. What is the reality of the situation? You see, when a seller breaches an agreement, you have basically two options, and neither one of them are great. I'll say that. They're both difficult. So the first thing you can do if you're a buyer and a seller refuses to close is to sue the seller for what is referred to as specific performance. Now, specific performance, that type of lawsuit, that's the nuclear option. Okay, that's what it is, because it's a legal remedy where you're going to go to court and you're going to ask the court to force the seller to honor the deal and sell you the property. Now, that is an expensive path to take, and there's no guarantees that a court is willing to do that. Now, maybe 20 years ago, courts might enforce contracts, but look at what the way the legal system is today. You go in front of a judge, you've got the seller there who's going to be crying and saying they're in this difficult situation. Here you are, the real estate investor that's sophisticated. You came to the table, offered him a deal. The judge doesn't really understand the nature of a short sale transaction, which I'll describe here in a moment if you're not familiar with this strategy. And they end up siding with the seller and not forcing you to sell them, because many times it may be their personal residence and they don't want to see them homeless. So it's a possibility, it's a remedy, but it's not the best remedy, because what happens is that every real estate, and this is what you're going to argue, is that it's unique, right, under law, and that monetary damages aren't sufficient to make you whole. But getting judges to buy off on that is really difficult, and it's oftentimes the worst part about this is it's slow. And so you have to prove many times that you as the buyer, you performed all of your obligations under the agreement, and this could take up to 3 years. And so if I'm an investor and I'm looking to flip property, does it really make sense for me to tie myself to a deal like that? Because it's definitely going to kill my momentum moving forwards. Because if you've never been involved in a lawsuit before, here's a wake-up call for you. It's very emotional, right? It's going to tie you down and it's going to distract you. So what is your second option then? Well, your second option is going to be suing for damages. And so what this means is you're going to sue to get back your earnest money deposit, which you should get back anyways if the deal was structured properly. But the other thing is that you may have out-of-pocket expenses that you incurred, like inspection fees or appraisal costs or even title searches. And so this is where it gets into the weeds and it gets a little sticky. Because again, it's legal fees, right? You're suing, hopefully you're going to get your legal fees out of it as well, because you have an attorney's fee provision in your agreement. But what happens in this scenario is that you're fighting for costs that the seller could always defend and battle you back on, and saying, hey, your remedy was limited to the earnest money, and any money you expended in evaluating the property, well, that's just the risk you take as an investor. And so either choice, either specific performance or suing for damages, typically they're not a great choice either way. And if you get your earnest money back out of the deal, well, that's considered to be a win. And so this was the issue that, of course, that came up in this Reddit post. What can they do? Because I've spent money, and depending on the amount of money you're seeking in damages, okay, you may end up in a small claims court. You would not even be able to get to superior court where you could be represented by an attorney. So these are a lot of things you have to look at. Okay, so what is a short sale? So a short sale is basically this. All right, you find a seller who has a piece of property. So here's my seller, and this is me. I'm coming in here, and I'm going to negotiate with this seller to buy this property. But when I'm buying it, really what's happening here is there's a bank over here, and the bank has to approve the sale. Because in a short sale transaction, the bank is getting ready to essentially foreclose on the seller and say, hey, you're behind on your mortgage. We're going to take this property back. But what you want to do is you want to get in here and say, hey, seller, let's work out with the bank so that the bank doesn't have to go through this foreclosure process. I'll step in and I'll buy the property. But the problem with these types of deals is that they're dependent upon a third party. That is, whatever you negotiate here between you and the seller, it's really you're seeking this party's approval here. So what this party's looking for is whether or not you as the buyer can demonstrate that, hey, you can actually buy this property, okay? So, and they're also looking at the seller as well, that the seller can no longer afford to pay. They have legitimate financial hardships. So all this is in the mix when you're trying to engage in a short sale transaction. So what can happen here, which is what went wrong in this Reddit post, is that whatever financial hardship this party was suffering under, somehow that was alleviated. So they felt they no longer had to sell, or possibly what it alluded to is maybe they found a better deal somewhere else where somebody offered them more money. So whatever the case is, they backed out. And so that makes it really difficult for us as real estate performers, our investors, is that in putting these deals together, there's always that risk that we're not going to be able to get the property. Now, what should you do from a planning standpoint if you're entering into short sales? So if you're going to be negotiating a short sale, here's what I would say to you. Never spend $1 on anything, right? Appraisals, inspections, until you have a signed, executed short sale approval letter from the lender, right? You want to make sure that the lender signed off on this, because that is always the problem in these types of deals when you're engaging in a short sale transaction. Once the lender is signed off, then you know, hey, at least you're safe to move forwards, that the lender's willing to commit to this deal. The second biggest mistake that I see here is that investors make is relying on standard, boilerplate purchase agreements, because they believe that, any form of contract is legal and it's protective. The fact of the matter is, as an attorney, it's not. The moment the seller gets a better offer, as I talked about here, then they could walk away from your deal. And so this could be a problem for you. So here are some essential contract clauses that I say you should have in your purchase and sale agreement, especially when you're working in short sale deals, to make sure that you're protected. Number one, what you want to have is what we'll call a high stakes earnest money clause, all right? So standard earnest money is a joke, right? Many times what they'll do is they'll put in a small dollar amount in there. Maybe it's 1% of the purchase price. But listen, if you're a serious investor here and you want to make sure this deal sticks, what you need to do is require a substantial earnest money here deposit, say 5% or more. So when that money goes hard after your short inspection period is up and over, if the seller backs out, then the contract needs to stipulate that the buyer is entitled to the full return of the earnest money plus a penalty equal to the same amount of the earnest money itself. So see, it's a double-edged sword in a sense. By doing this, what you're saying is, hey, I'm going to put down earnest money. Let's say it was a $200,000 deal. I'm going to put down $15,000 in earnest money. So the seller looks at that and they think, oh, this guy's really serious about this deal. He's willing to put up 15 grand. He's not going to walk away. Yes, but I'm also going to put that penalty clause in there. So if the seller backs out, I get my earnest money back, but they have to pay me liquidated damages, okay, of 15 grand on top of that. So this really serves as a way to incentivize the seller to move forward with the agreement. I've seen talk to so many buyers who always want to keep a low earnest money so they can walk away from a deal, even if their money's gone hard and they don't risk losing any more than the earnest money. Well, here's a newsflash for you: seller could sue you. But the fact of the matter is, this is one of those situations where you may want to rethink that to make sure you keep that seller on the hook. Okay, so the second clause is you want to have a specific performance requirement. Now, here's what I would do in your contract. I would ensure that your language not only allows for specific performance, which means they have to sell you the property, but it mandates it as the primary remedy in the event of a seller default, right? So you spell out that, hey, if the seller tries to back out of this deal and I have to sue, then the primary remedy is that the court must force them to sell me the property. So if you specifically put that in there, that gives a judge then something to look at and say, well, seller, did you read this, right? Do you understand that you have to sell them the property? So if there's property that you really want and you're really motivated to buy it, I would put a clause like that in there to make sure that's in there. Now, the third most important clause you have to have in any purchase and sale agreement is the one that gives you teeth in order to go forwards and sue a seller in a situation where they're trying to back away. And this actually should be in every agreement that you put together, and it's referred to as an attorney's fee provision. You see, most contracts that I review that are sent to me by real estate investors, they're oftentimes silent on this. They don't even think about this, that is having a provision in there that states that if the contract has to be litigated, that if either side starts litigation over it to enforce the terms of the contract, then the winner, that is whoever prevails, is entitled to their legal costs. You see, this is what acts typically as a deterrent, why most people don't try to enforce contracts, because like I talked about earlier, it could take you up to 3 years to fight this agreement. And that means you're coming out of pocket, paying your attorney to go to court. And if you win and you don't have an attorney's fee provision in there, you're still out the amount of the attorney's costs in order to get to that position. So the way you prevent that is you put in a provision that mandates that the losing party pays the winner's attorney's fees and court costs. All right, so this turns the table on someone who thinks, well, hey, if I walk away and they sue me, well, what am I out? Well, if you lose that court case because it can be shown that you're the one that breached the agreement, then you have to pay their attorney's fees and you have to pay your own attorney's fees. So this is a very important clause to have in there. So if you build these 3 clauses into your agreement, it's really going to add teeth to it, and it's going to reduce most likely the risk that you have sellers who decide, hey, I found a better deal, I'm gonna go take that instead, because it comes with a substantial cost if they try to do that. So here's what I'm gonna tell you, all right? Wrap it up real quick. When a seller backs out, especially in a complex short sale scenario, which many of them are, your first move, do not panic, all right? But look at your agreement. Your second move is going to be decide if the financial prize is worth the fight for specific performance, all right? Is it really worth going after this property, knowing that a short sale contingency can sometimes make that fight harder? Okay, the only true protection, okay, that I would tell you is you just mitigate your risk before you sign anything by putting in those 3 provisions that I mentioned here in this video. Make sure if you don't have them in there, you have them in there. And if you do have something that speaks to it, make sure those things are ironclad. Because at the end of the day, I mean, you can have the best legal structure, LLCs and entities that are set up to protect you. But this type of deal, it's not about protecting you. It's from lawsuits. It's about you bringing a lawsuit and making sure you can enforce the contract. You want something that is binding that's going to force the other side to come to the table. Listen, if you want to learn more about how to structure your entire investing entity from your LLCs to your operating agreements to corporations and land trusts and how taxes work, then I invite you to our free 1-day tax and asset protection workshop for real estate investors. Listen, at this 1-day event, we do a deep dive into how to set up your structures the right way as a real estate investor. And all you have to do is go into the show notes. There's a link. You can click on that link. You can get registered. It's completely free. free. And I guarantee you, if you attend that event, you'll leave that event in a better position than when you started. Listen, I hope to see you there.